matter of F children.
Yes.
May it please your lordships, I together with Miss Smith represent the mother in this matter, and the mother is sat the report on the left hand side which you place out.
Yes.
The local authority are represented by my little friend Miss Fottrell Casey and Mr. Douglas. The father, who is not present, is represented by Mr. Badgie, King's Counsel, and Miss Withers, and the children's guardian is represented by Mr. Barnes, King's Counsel, and Miss Edinson.
Yes. Thank you.
Well, you'll be aware that this matter concerns two children. D, who is 4 years and 5 months old, and Z, who is 1 year and 8 months old. And you will be aware from the papers that they are currently placed with their mother in a residential setting where they have been since April 2025. And the court will be aware that by way of order dated the 16th of June, permission was granted against the decision by Her Honour Judge Scannell sitting at the Cardiff Family Court on the 7th of May when she made care and placement orders in respect of the children. I first of all clarify whether you have received the skeleton argument on behalf of the father. It came in yesterday.
Yes, thank you.
Yes. Thank you.
The court's concerned with 3 judgments. The threshold judgment, which is dated the 24th of November 2025. Judgment 2, which we've all referred to as the welfare judgment, which then led to adjournment to Judgment 3, that being the judgment on 7th of May, when the orders were made. Before I address you on the grounds, may I make some concessions which, if aren't readily apparent in our skeleton argument, we do so now. There's very little dispute between the parties as to the factual determinations which were made by the court in any of its judgments, and it's quite rightly set out on behalf of the local authority and the Guardian that the findings in respect of threshold were not appealed. We also acknowledge that there is little, if any, dispute as to the relevant legal principles to be applied and considered by this court. And in our skeleton, we have candidly and readily made the concessions that the learned judge considered the relevant authorities, which you find in the authorities bundle, and that she did consider the matter of proportionality, which again is reflected in the authorities within the bundle.
Could I, just in a neutral way at this stage, say that because there's a lot of experienced counsel in this case, the authorities bundle, for which we thank you, is not compliant. If you are going to put authorities in, then you have to put in the reported versions. It's much more helpful to the court, and that hasn't happened. Also, the rules make clear that you have to put in the statutory provisions. This decision was taken under statute, and the fact that those practicing in this field know Section 1 of the Adoption of Children Act 2002 by heart doesn't mean that it should not appear at the top of the authorities bundle. That may be a matter of some significance because, as a matter of fact, nobody during the course of the proceedings referred to that either. Before we go on, could I just make that point? Not to return to it, not by way of any particular criticism, but in future cases we'd be glad to have that situation.
Lord, I will fall my sword in respect of the first part of the correct authority.
It's not a partisan point. It's it should be by now well known.
No, may I continue with the concessions that I was making? We concede that the 3 judgments are detailed and they have to be read together. We acknowledge that. but in particular in relation to our ground 2, which I will return to later, we say that particularly judgments 2 and 3 need to be read together for the reasons we set out in respect of what we say was the linear analysis in substance. We do not accept that we have sought to minimise the findings that have been made. A perusal of the judgment by Perron, I think it was the second judgment, recognised and commented upon the concessions that were made at the final hearing on behalf of mother as to the effects of domestic abuse on children. And we were quite clear about that, and we were quite clear during the hearings that mother's position was, I do not accept the findings that have been made by the court in November 2025, and we have not sought to hide against that reality. Lords, may I turn to ground 1? And it will be seen in all the skeletons and in the judgments of the learned judge that there was particular focus on your lordship's judgment in Re T and the questions which are set out, and my lords, you will find that in the appeals bundle, page 72, and if you are working electronically, it is one page further on, page 73. And also, we refer to what is set out by your lordship, paragraph 34, and the last sentence, that the assessment of actual likely harm is not the same as an all-round welfare assessment. And the argument that we seek to advance in our skeleton is probably more succinctly and eloquently set out in those that skeleton argument filed on behalf of the father. That might well be the benefit of filing last in this case. But, Lord, if you were to consider what is set out at paragraphs 18 to 20 of Father's skeleton argument, that encapsulates our submissions as to the application of the Re T questions and the approach to proportionality. And we have addressed it in a different fashion in our skeleton argument when it's referred to as mother's intellectual refusal to accept the nature of risk, and therefore she's likely to violate any safety plan. And you will note, Lords, in our skeleton argument that we have referred to what we describe as the powerful impact of the external locus of control, of which we say there was significant empirical evidence before the court which was not sufficiently considered and not sufficiently balanced. And the court will note that we have set out what we say are external locuses of control, and we make the difference, the differentiation between what we say is an external locus of control as opposed to what was described and found to be a litigation position. And we make a distinction between that, because the litigation position, we would term it in this way, that somebody is telling the court that they will engage on a course of action, but they take no steps in order to further it. Whereas we respectfully submit that the mother falls in a different category by reference to her decision, albeit belatedly, to separate from father in the cultural context, to institute divorce proceedings, and to comply with safety plans and boundaries at a placement which is endured for 15 months. your lordships will know that it is no easy exercise for a parent and a child to be at a residential placement for such a long period of time. And it's often the experience of it all that parents often fail very quickly and migrate back to an abusive parent. But in this case, we have none of that. And
Well,
another,
could we gather a little bit more information about the unusual state of affairs that exists in this case? We have two asylum-seeking parents in different places. Everybody is a national of Pakistan. Nobody has any right to be here. At the moment, as I remember, one parent is in North Wales and the other is in South Wales. Bristol. The move to North Wales took place as a result of decisions taken by the Home Office or decisions taken by the local authority, or both?
the move from the Caerphilly area, South
Yes.
Wales, in April to the placement in North Wales was as a result of the local authority's decision and then during court proceedings.
Right. So the premises in which the children are living with their mother has been sourced and paid for by the local authority.
Yes.
Right. So it's been horrendously expensive, and it hasn't been dictated by asylum accommodation issues.
No, it's, your lordship's correct, it's been funded entirely by the local authority. Obviously, it wasn't intended to be a placement of such long duration.
As a matter of interest, we're going back into last year. At what point was the final hearing anticipated? At the point when the mother moved into that accommodation?
It was originally listed to commence at the end of September.
Right. So it was a placement measured in 3, 4, 5 months,
Yes.
was the original intention.
Yes. Well, can I add to that in terms of the father? He is under Home Office
Yes, that was
restrictions.
my next question, that he is obliged
Yes, he is.
to live in Bristol. So the arrangements that might be made for the parents under the auspices of their asylum claim are presumably quite unpredictable,
Yes.
in that rests on decisions taken elsewhere and largely by the Home Office.
Yes, and Lord, may I add to that? A feature of this case, certainly in the April 2026 hearing, was what would happen to mother and the children if they were discharged from placement.
Well, can we come to that in a moment? I'm
Sorry.
trying to at the moment understand what their historic situation has been. So is it necessary that the placement in North Wales was approved by the Home Office before you could do that, because the mother was an asylum seeker? Was it done, as it were, cooperatively in that way? Maybe there's no evidence about
The
it.
local authority may be a better place to assist you with that. I will need to take instructions.
Well, there are obligations to notify the Home Office about your location, so it would be instructions from your client.
Well, I don't need to go into that too deeply, because the significance for the future, once we can tease this out, is in trying to understand, and this is what seems to me to be an unusual feature of this situation, that the options for future practical arrangements are very uncertain for both parents, not only as to whether they are going to be able to remain in this country, but also, if they do remain in this country, where they will be obliged to live.
Yes.
While we're asking questions, I just ask this. I couldn't see in any of the core or supplementary bundles details of where we are on the asylum claims and details.
Well, what has happened with the appeal is that the last time it was before the court, I believe it was in June, it was adjourned generally to await the outcome of these proceedings, and I have seen an order requesting disclosure of the judgments from the immigration tribunals, and it's our understanding that those judgments have been forwarded to that tribunal. So I hope that answers your question.
So that's extremely helpful. I assumed something like that wouldn't happen, but I couldn't see it in the bundles.
And my lord, on that particular issue, I think we do set out in our skeleton argument that mother is now making a separate claim to father.
Now you were going on, I think, to speak about what the court was told about the options for the mother and children at such time, which will at some point arise, that they have to leave the North Wales placement. What was the evidence about that?
Your Honour, my lord, that was explored in the second hearing, and you will see reference to the support witnesses that was filed on behalf of mother from the asylum stroke refugee organisation in that area in North Wales, who were saying that they were accustomed to liaising with the Home Office in similar circumstances where there were Child Protection Agency involvement, with a view to securing a placement in a particular area. And that's what we were inviting the court to consider. And of course, if the local authority was sharing parental responsibility for the children, then they too, we respectfully submit, would have an onus on them to liaise with the Home Office as they would have done when the placement took effect in April 2025.
Well, I mean, normally in the easy case, a judge is faced with knowing what the realistic options are, and knowing what the realistic options comprise of in terms of the main arrangements for life. It sounds as if this was not such a case, where it would follow from a decision that the children remained with their mother, that it wasn't going to be in the current address indefinitely. It would be at some other address which would be found for them in combination between the local authority and the Home Office.
Yes, my lord, that was it. And we were imploring to the court that the local authority would hold in parental responsibility, need to liaise with the local authority in Wrexham. That is the area that mother wanted to continue to reside in because of the links that she'd formed with the MOFs since she'd been up there, and the individual organisation that I've just referred to. And that they would need to take all steps which they are required to do, as your lordship knows, to try and secure the children with their mother, which would mean, as I've already said, entering into discussions with the social services in that area.
Remind, the father's family is in Bristol or in Newport? Newport. And what is the significance of all this happening in Wales? Does it mean that the options for the mother and the children are limited to Wales, or is this a UK or an England and Wales issue?
It's an England and Wales issue.
Why England and Wales and not UK? Because asylum is to the UK, not to England and Wales.
My lord, I take your point then, that, of course, I was thinking in terms of the exercise of parental responsibility by a local authority and the calling upon another local authority in England and Wales, but I acknowledge the immigration aspect.
Thank you. Well, for our purposes, we don't have to regard that this as being a Wales-only
No.
issue.
No.
And of course, you've spoken of the local authority having parental responsibility. That could only exist under a care order or some configuration of an interim care order.
Indeed. And I'm not going to delve into it, but there are obligations upon Welsh local authorities under the 2014 Act that does not prevent the local authority requesting assistance from a local authority area of England.
Sorry for this lengthy interruption, but it will help us when we come to consider the practicalities of this. So the picture facing the judge was that there was a likelihood, if the children remained with their mother and left the placement in North Wales, that they would in fact gravitate back to South Wales.
That's what she set out in her judgment, yes.
And that was that was what the mother wanted herself.
No, she wants to stay in Wrexham. Where she currently?
Sorry,
Where she currently
I'm sorry,
is.
I was just getting my geography wrong. Right, so so the mother wants to stay in North Wales. The local authorities in South Wales.
Yes.
Okay, thank you.
My apologies.
No, my fault.
Did you say proximate to where she currently is?
Yes,
In other words, she's not necessarily counting on the same accommodation being where she stays in the medium and long term.
Without indicating where the placement is on the life.
No, I understand.
It is where she currently is proximate to Wrexham, where she.
Yes, I see. Okay, thank you.
Lords, I was addressing you as to the external locus of controls and her compliance with a placement, and also it was noted quite strongly on her behalf, or advanced quite strongly on her behalf, that at no stage had she sought out separate contact with father at any stage that he visited the placement on a weekly basis. I do not wish to repeat what is set out in our Skeleton argument as to the balance of harm, which is also amplified in the Skeleton argument on behalf of the father. And the balance of harm lies, we say, in the context which is paragraph 34 of RET, that the assessment of actual or likely harm is not the same thing as an all-round welfare assessment. May I turn to ground two?
Just a moment. You're referring to
RET, my lord.
what paragraph?
34.
And it is
Thank you.
paragraph 34.
Yes.
May I turn to ground two? Laws, again, the relevant legal principles are set out in significant detail in the Skeleton arguments, particularly those on behalf of the local authority and the children's guardian. And in particular, the guardian's Skeleton argument at electronic number 70 to 71 sets out the matters which were considered by Justice McFarlane and the then President in Re R. And maybe it will be of assistance to the court if I took you to the authorities bundle, unless that's unnecessary.
So which page are you on the electronic bundle? Is that because there's a disconnect between the digital?
I think, my lord, it's 2 pages out, so
Yeah.
if I took you to,
So submissions in response to the appellant's appeal. Is that what paragraph 37?
it's
paragraph 34.
Thank you very much. That's very helpful.
electronic 70.
Thank you.
And paragraph 34 sets out the observations of the then President and Lord Justice McFarlane in Re P. And whether in fact the judgments are linear in structure or linear in substance, and that, we say, is what this court has to consider in a nutshell. And we again draw reliance upon the way in which this is summarised on behalf of the father in that skeleton argument at paragraphs 22 and 23. And we say at paragraph, we support what is set out at paragraph 23 in our skeleton argument. But what in essence happened in judgments 2 and 3 was that mother was ruled out as being a realistic option in substance, although not in form. And that is a matter which the local authority invites you to consider in its skeleton argument. With the local authority electronic bundle number 9 in the core bundle, sets out at no point in judgment 2 does the learned judge rule in or out any realistic option, and she exercised caution. We respectfully set out in our skeleton argument that if you analyse the substance of the decision which was made on the 2nd of April, that is precisely what she did. And we have set out in our skeleton the paragraphs which we rely upon, where having analysed risk, having analysed ways in which that harm may arise and whether it could be mitigated, that the lengthy analysis that then followed essentially took mother out of the equation as being a realistic option, and then left the local authorities' VBS analysis we describe as nugatory.
I'm just trying to pick up this is your paragraph 56 to 59, page 47 to 48, is that right? Your skeleton argument.
Yes.
Just to understand the submission, the judge is not here seeking to make a welfare decision, but to reach conclusions about the level of risk represented by the children remaining with their mother. Nevertheless, your case is that effectively this rules the mother out. Is that the...
Yes, and what was the local authority going to do, having received this judgment, having already approached the case in April, as your lordships see, on the basis of only 2 realistic options, which you see in the ReBS minutes leading up to the March.
Those were long-term fostering or adoption.
Yes. And the learned judge acknowledged the deficiencies in the analysis, both by the local authority and the Guardian. Quite properly invited the local authority to and the Guardian to address errors to the realistic options, but at the same time, we say quite simply made that exercise fait accompli, because if one looks at it simply in this way, please go away and consider the realistic options and include mother as a realistic option, even though I have at length found that she is not a realistic option.
Is that fair? Because, I mean, it was always possible for the local authority and the Guardian to come back and say, well, we propose a mother with a supervision order.
Well, we know how they approached it leading up to the hearing in April. We know that they were, for their reasons, and I make no criticism of the position they adopted, but they approach it with this is adoption. The judge then fortifies their conclusions but said, well, you didn't go about it the right way by considering mother in that analysis. Now I've added to your welfare concerns and your evidence, your evidential platform. Go now, consider her as a realistic option in the background of that judgment. Whatever conclusion were they going to arrive at? And this is where we again return to what is set out at. I do apologise. We'll be taking you to the authorities bundle briefly. Yes, my apologies. It's the electronic 189 in the authorities bundle, which is the authority of BG. I invite you to consider what's set out of paragraphs 49 51 and 52. Those are the submissions which were advanced before his lordship by Mr. Horsley. We say that this is on all fours with the position of the learned judge and a mother in this case. We say that this is a classic linear approach adopted in the two judgments. Again, my lord, I don't wish to repeat everything that I've set out at length in the Skeleton arguments. Is there any matter that you wish me to address?
Could we look at how the judge left the matter in the second judgment? Trying to find a reference.
I think it's 198 of the core bundle.
Yes.
3-2.
194.
312, which is at page 194, she turns to the issue of the local authority's decision making, and this is part of the passage that follows. And she then, between 319 and the end, expresses concerns about the approach taken by the local authority and the Guardian. In essence, as I understand it, your submission is that the judge fell into the trap that she herself identified.
And I was going to take you to paragraph 320, which I say is a shining example of this, where she sets out there's no comparative analysis of the competing options. The evidence is completely constructed in a way to rule mother out as a realistic option, and then to consider other options before deciding adoption is the right plan. The consequence of placing her in the unrealistic category is that there is no comprehensive analysis of the advantages and disadvantages. And in essence, to draw upon your lordship's point, we say that that's exactly what she did. She placed her in the category of unrealistic, and her judgment, as I've already set out, ruled her out as a realistic option.
This is an issue which arises from time to time. The decisions from BS onwards refer to realistic options. And I have a sense that, and that has to be applied by people who are not lawyers, who are making plans for children in local authorities, parents who are considering how to respond to proceedings. It's quite common, in my experience, for people to describe options as unrealistic because they're not preferred or very strongly not preferred, when that's not, I think, the intention of the expression a realistic option. A realistic option, it might be described as one that deserves consideration, or I'm not quite sure. Any help from the bar? Because I'm sure that this is not the first time that this debate has happened. But this is a case in which the mother was ruled out as a realistic option on the basis that she was not the preferred option. The judge rightly identified that as being wrong. It may not have any ramifications for the appeal because the judge recognised this issue, but it may be something that needs to be re-emphasised.
Well, just finally picking up on that. When we came to the March-April hearing and we had the deficient RBS analysis from the local authority, there was no pushback from the learned judge or any advocate that what had happened was procedurally flawed because mother should have been considered as a realistic option, notwithstanding the fact that they had these findings of harm from the November 2025 judgment. But it was quite wrong in circumstances where there were positive attributes to the care that mother provided to the children. The fact that she'd never been separated from them and had been in a placement with them for, at that stage, 12 months, for her not to have been even considered as a realistic option.
What I don't understand is this second hearing took 5 days, the first one having taken 8, is why the court embarked on this process on the second occasion at all. I mean, I think I'm guessing that you flagged this point up at the beginning of the second process, or is it simply something that emerged during the course of the hearing?
The second hearing, we certainly expressed our disquiet and reservations as to how you can arrive at any welfare.
Yes, I'm talking about there would have been paperwork going into the second hearing. Was there an issue raised as to whether we should be doing this at all?
No, not by anyone.
Right. So the case proceeded until the end of the second hearing before there was then an argument about whether the RBS exercise had been properly carried out.
Correct. It was explored during the course of the evidence, as you would expect, and then the submissions made. The local authority maintaining that, and the Guardian, that there was a sufficient RBS analysis, and you will see from the second judgment that the linear judge acceded to our submission that it was not compliant.
Unless we're told otherwise, it doesn't seem as if there's any reason why that debate couldn't have taken place at the beginning, because these analyses are meant to appear in paperwork that is presented to the court and then pored over. It's just as a matter of fact, it wasn't dealt with at the beginning.
No, well, because the local authority and the Guardian were saying, well, yes, that is a RBS compliant analysis.
Yes, but it doesn't take evidence to determine that, does it? It could have been. I mean, I'm asking you because you were there.
Yes.
It seems that unless some explanation is given, this is something that could have been considered at the beginning, rather than the case being adjourned at the end.
The first, Lord, I accept, and the social worker was the first evidence, first witness. The deficiencies in the RBS analysis were put to her. There were concessions made that she hadn't considered mother as a realistic option, but the proceedings continued.
Thank you. Now, you were about, I think, to finish, but can you tell us more about what you suggest should happen if the appeal was to succeed?
Well, I have taken note of the concluding paragraphs in all of my many friends' skeleton arguments, and it would appear that this matter, as we suggest, should be remitted, most probably to Ms. Justice Morgan for case management, and then she can consider the way forward and whether there is a lacuna in the evidence which we identified, but we acknowledge is not subject to appeal.
So, if matters did reach that point, stress that I'm only trying to cover all the ground. If matters did reach that point, then questions as to what did the future potentially hold for a placement for the mother and children and so forth would have to be subject to directions by that judge.
Yes.
It's not something that we can further explore.
Yes, and we make no secret of the fact that that is a matter that we would invite the tribunal to consider, especially since there's a further passage of time since the separation has taken place from father. And that would be just one of the factors that we would invite there to be fresh consideration of.
Thank you.
Could I just confirm with you, Mr. Rees, you're inviting us to conclude that the findings about the mother in the second judgment effectively closed off mother as a realistic option by the time a compliant analysis was actually prepared. And you've invited us to look at paragraphs 284, 285, 297, 307 and 308 in your skeleton argument. And I just wanted to check that those are the paragraphs that you want us to look at. That's paragraph 59 of your skeleton argument.
My Lord, revisiting it over the last couple of days, I'd also respectfully invite you to consider paragraphs 310 and 311.
Just a second. Yes, thank you. Thank you very much. Thank you, Mr. Rees. Mr. Bagchi.
Well, I don't know if it's convenient to hear me next because I support the appeal, as my lords have seen.
Yes.
May it please your lordships. There's a fairly short skeleton argument filed in haste. We only got funding on Friday. I don't know if that's an advantage or a disadvantage. In many ways, it is an advantage. My client is not present. There are certain logistical problems that he's faced in getting here. I'm told that it's likely that he's watching online, so he will be participating in that sense. There's not a huge amount I seek to add to what my learned friend has said. The points that we made in our skeleton argument are quite short and rather speak for themselves. Before I forget, may I just address the point raised by my Lord Justice Peter Jackson a few moments ago about the term realistic, because that brings to mind a consideration of that in one of the authorities that we have in the bundle, thankfully. It's in a judgment of the late Sir James Mumby from 2015, and it's at page 158 or 159 PDF in the authorities bundle in the case of Re R, when he addresses directly the meaning of the word realistic or realistically. So that's PDF 159, paragraphs 59 to 62. I'm not sure it's going to help me to read the whole thing out, but it's there. I'll just pause for a moment whilst the court absorbs that. And in particular, paragraph 61, where he addresses directly what is meant by a realistic.
Thank you.
So we're turning extremely briefly to ground one. The one point we've made is that, of course, one can readily see, with vast experience of this type of litigation, that the court expects a certain process and almost a dialogue post-fact finding with those found to have perpetrated certain acts and those having to respond to it, in this case the parents. And so the court has made findings of fact which are sufficiently serious to cross the threshold, but given the parents the opportunity to reflect on that, which is the standard process, and then for a risk assessment to take place in the context of that reflection. And in many, many cases, as a result of that reflection, there is forward movement, there is some acceptance of the underlying facts, and there's a willingness to work with therapeutic agencies to move forward towards some form of rehabilitation. And that is the system working at its best. The problem in this case is that on an intellectual level, for reasons which one can speculate about, but doesn't really know, neither parent seemed to overcome the obstacle of accepting the underlying threshold findings and moving on from that in a way which alleviated the concerns of the professional assessors that all would be well once the time came for professional oversight to fall away. And so, in a sense, the dialogue between the learned judge and the parents was a difficult one. And one can see this playing out, particularly in Judgment 2, where the judge is expressing concerns that there simply has been no forward movement by the parents in relation to the acceptance of risk. And that gave rise to a certain stalemate on both sides. That's quite an unusual position, not unheard of. In cases where the findings of fact are extremely serious and the level of harm sustained by the subject children has been very serious and life-threatening, one can see how that very set of circumstances and the findings are almost giving the court the answer, because the findings are so serious that unless there's an acceptance of baseline risk and a lot of work being undertaken by the parents to mitigate the risk, it's hardly ever going to be safe to reunite the family in the same way. and some very serious cases end in that result. Here, an unusual situation where the core findings were obviously serious and significant, but on the spectrum of seriousness, actually quite towards the lower end. So that might call into question as to what weight you give to the particular findings of inflicted injury on the children, and I would respectfully submit that they are at the lower end. But there was another finding in relation to coercive and controlling behavioural and domestic abuse, which I think I have to accept was compounded by the failure on the part of my client to acknowledge that, and the failure on the part of the mother to accept the underlying risk and to move forward on that basis. So in the whole context, one can see how that might have been of more significant concern to the court, because the court was trying to plan for the future and whether or not this family would be reconstituting itself into the same circumstances which prevailed when the harm took place. So that one readily acknowledges that's a concern. But when you have this stalemate, then that's a more difficult question for the court to stand back and ask itself, well, what does that mean in terms of risk? Because if it's true, seems to be true on the face of the evidence, that the parents had in fact latterly complied with the safety plan, and that notwithstanding what I described as the mother's intellectual refusal to accept the baseline risks, that she had fully complied with requests by the local authority to stick to the plan, and had not moved forward to act of her own motion to expose the children to risk. So she will go along, she'll do what she's told, effectively. Then how does that affect the balance of risk? And I would submit that probably attenuates the risk to a certain extent and has to be acknowledged. So what my learned friend described as the external locus of control is really the baseline question as to whether or not these parents will do as they're told, notwithstanding that they don't accept it, but if they know that moving forward, the sword of Damocles is hanging over their head, for example, under a supervision order with a safety plan, and the message from the court saying effectively to the parents, you are at the last chance saloon, this is the last chance you'll have to comply, otherwise your children will need to be removed, because we're laying it on the line for you. You must comply with this safety plan because the risks are sufficiently significant. Then would that not have been a better way, which in a sense recognises what I've spoken of in the document as the devastation to these children caused by an enforced separation from their mother in circumstances where the harm they have suffered has been on the spectrum relatively low. They are securely attached to her. She's the only primary carer that they've really ever known, certainly in the last 2 or 3 years, and in circumstances where all of the consequences of being removed and placed with a family into a foster placement, which may have to ultimately result in long-term foster care for them, children of this age, because placements for children of this age are always difficult. It is a situation which the judge ought to have looked at more critically in the overall balancing exercise. And that's the point that we make in relation to ground one, that there was a disconnect between the assessment of risk, given the available options in terms of safety planning and risk management, in contrast with the very, what we say is almost guaranteed significant emotional harm which we cause to the children by being wrenched out of their care of their mother and placed in a placement which might be a holding placement, hopes for an adoptive placement, but no guarantees, otherwise long-term foster care from children of this age, so looking at 10, 12 years, longer than that, 15 years in long-term foster care. And I think we all know that does not come without its risks for those children. And so would it not have been better, we asked rhetorically, for the judge to say to the parents, okay, I'm not impressed or satisfied that you have accepted the baseline assessment of risk, but you will have to comply with this safety plan, and there will be ongoing oversight by the local authority, for example, under a supervision order. In theory, although there are problems with it, under a care order. That is difficult. Under a supervision order, which could be extended under the legislation up to 3 years in exceptional circumstances. And so the local authority are on the ground. There's a network of oversight from school, medical agencies, the children remain under a safety plan, under a child protection plan, so the local authority remain in the background, overseeing it, ready to step in, if necessary, to safeguard the children if the parents simply turn their back on the safety plan and breach it. And that would have been, in my submission, given all the available options, the least worst of all available options at that time. And the learned judge simply didn't give sufficient credence to that as an outcome.
Is there any particular reference in the papers or the judgments to a supervision order as being an option worthy of consideration?
I'll be assisted in relation. I can't remember that it was ever considered as any type of realistic option. The issue was really between adoption and maintaining the placement. And I'll be told if I'm wrong, but there was no detailed forensic consideration of the rival advantages and disadvantages of a safety plan underpinned by a supervision order. Then my learned friend reminds me that his case before the learned judge was that the concerns were sufficiently elevated to warrant the making exceptionally of a care order with the child placed at home with the mother. And I think we know that there's more of that these days than there used to be 10, 15 years ago, but even that is problematic because the local authorities they don't like that because they have all the responsibility under the statute, but not much power to control day-to-day events on the ground. So that would be a difficult balancing exercise. And the supervision order with a child at home is a much more realistic outcome.
The judge's assessment was, regardless of the amount of supervision or control, that it was likely that the family would reconstitute itself if it possibly could. I mean, I had understood this appeal as going more deeply than some of the submissions that we've heard. And in confronting the court's response to that possibility, and whether this appeal, I'd like to understand whether this appeal is being presented on the basis that if the mother and father were able to resume their relationship, which would likely involve some degree of domestic abuse, which would likely involve some risk of injury to the children, whether that in itself was terminal, or whether I'd understood ground one to be making a deeper point, namely that this just isn't bad enough.
Yes, well, it all depends on the risk metric. If the judge had found, of course, the judge has made certain findings of fact as to what had happened, then the judge has to make an assessment of what was likely to happen and how likely.
Yes, well, the judge was very sceptical about
yes.
what your client and the appellant were going to do, and that doesn't seem to be. There's no attack on the factual approach. Me trying to be as realistic as possible. If it would be a very difficult submission for an advocate, for a parent to make, that if there was on the face of it, an overt determination, let's just say the parents have gone into the witness box and said, no, we will get back together. We will, if these children stay with us, we will make a plan, we'll be back together within 8 weeks. And in those and reconstitute precisely the same household, which gave rise to the harm in the first place, in circumstances where nothing had changed to lower that risk. There'd be no acceptance, no therapeutic. What would that mean for families around the country?
That would place them in a very difficult position. That would mean that the courts inevitably, in that fairly unusual set of circumstances, would have very little option but to impose a degree of safeguarding by the making of orders which protected those children from the risk of almost inevitable harm. That's not this case, by the way, but that's an even more extreme example, but just to test the example. So if it was guaranteed that the children would be harmed to a single...
Children are harmed all over the place. That's why these cases are difficult. And we've said again and again that the fact that children will be harmed at home is not a basis for adoption. It's a question of judgment that has to be made.
It's a basis for safeguarding, but it's not a basis for adoption. I respectfully agree with that entirely, and that's the law. And it demands a safeguarding response. It would be irresponsible for the public authorities, or indeed a court, simply to say, good luck, get on with it. That would never happen. But for that to track immediately to the most extreme form of safeguarding, physical safeguarding, adoption, would be disproportionate, because that still requires an intense focus on the realistic options, which include a safeguarding option without necessarily separating the child from the parent.
May I ask just a question about options? I mean, because we know that neither parent had the right at this stage to be in this jurisdiction, was there any consideration given as to the viability of the claims for humanitarian protection or asylum, and therefore the likelihood of removal of the father if the father's present was the concern? Or was it just, I get the impression in all these cases, rather ignored?
Well, I think that the position was that it was acknowledged that there were asylum claims. I'm not sure it was ever addressed directly in terms of any forecast or any legal advice as to where the appeals to the adoption process might end up. I rather assume that the prevailing view in the courtroom would have been that each parent would have asserted their strong Article 8 rights to maintain physical direct links with their children, if their children in this country. And that would feed into the appeals process in such a way as to, for example, prevent a father from being deported in circumstances where he's having a regular relationship with his children who are in this country. Though, as we all know, the rules in relation to adoption, the way adoption appeals change regularly, and there's constant trimming and amplification of that. So none of us are immigration experts. So I rather think it was based upon a general understanding of the way these cases work rather than a detailed understanding. I don't think there's any legal advice placed before the court in relation to that. Yes.
Thank you.
Surely the court needed to have an eye to the fact that one of the consequences of the rule that it made would be that the children would go into foster care, that the adoption process would then proceed as best it could. Hopefully at some point be found for the children together. That the parents' immigration situation would remain uncertain while that was going on. The children were then adopted. And then what happens next? The parents might then be deported, depending upon whether they had any contact or not. I mean, one of the outcomes of this would be adopted children, deported parents.
Yes.
Which is a most unusual state of affairs.
Possibly subject to any, I don't think any orders were applied for under Section 26.
You can have contact orders both at this stage or at the stage of adoption. And that if that was happening, then it might be that whatever the merits of the immigration, the asylum claim, the parents wouldn't be deported while they still had court-ordered contact. Anyhow, we don't know the answer to that.
No. I rather get the impression that the immigration issue was very much in the background, but was not in any way central to the submissions made in the courtroom or to the learned judges.
The only reference I could find to it is that the local authority assiduously worked out what the consequences for the children's immigration status would be if they were adopted, and the outcome would be that if they were adopted by British citizens, then they would gain British nationality.
Yes.
Can I just ask one further question? In your submissions, you talked about the risks of long-term foster care.
Yeah.
And that's perfectly obvious. If you sit in the criminal courts, we deal with people that come through the care system.
Yes.
Where's the evidence that's ever adduced in a family court about the risks? Because at the moment, one gets a distinct impression that it's all meant to be the shining state and everything will be all right, whereas we know it's not, and the reality of parental care. which, as we know, is
If I may say,
how
that's an
rules are.
excellent question, because it's usually dealt with on the basis of it's common knowledge that. I'm sure Melissa may be able to assist, because there may be research evidence. There's likely to be research evidence in relation to welfare outcomes of children who are in the care system under long-term fostering for over 10 years, and those who have the benefit of an adopted placement at an age where that can be realistic. The difficulty we have in all these cases, it seems that the baseline for children not being adopted is something like 5 or 6 years of age. As soon as they have a working memory of their birth family, and the arguments in favour of an open adoption with direct contact are defeated because of the hostility of the family from whom the children have been removed, then it becomes difficult. It's not impossible, but one senses that the target base of adopters in relation to children of that age is going to be diminished, because those children come with lived experiences of harm, and it's not something that they are ever going to forget. They know who their parents are. They know what their names are. They have access to social media and all of that. And that's an emerging problem, as the court will know in recent breakdown of adoption. That's been a difficulty. And one can see in the authorities which have emerged over recent years in relation to the revocation of placement orders by your lordship, there's much more greater understanding of all of these difficulties.
Well, these haven't found their way into our bundle quite rightly, but there are a number of decisions down the years about the difference between adoption and fostering and the advantages and disadvantages of both.
Yes.
But for children of this age, it would be right to say that long-term foster care would not be the obvious first port of call if they could not live with parents. But time is passing quickly for these children. Relevant to this case, there was an aspiration by the local authority to find a united adoptive home, and the judge was happy that would be sought. She considered the prospects of the children being separated as minimal, but it's not clear to me whether she considered the prospects of the children not being found an adoptive home together as being minimal. We'll get help about this, I'm sure.
I think in the judgment there's mention of the evidence that she'd had from the family finding process in relation to their optimism of not having to separate these children.
Yes, but down the line, 6 to 8 months, it was said that a decision would have to be made if we don't find a home for these two children together. A decision will have to be made about separation, but it wouldn't just be about finding two adoptive homes. It would be about leaving the children in foster care permanently, which could hardly be suggested without there being continued parental contact. If these children remain in foster care at quite a regular level of some kind, assuming the parents weren't deported.
Indeed.
But again, I don't know what the answer to that is, and the other parties will no doubt be able to help.
Well, it may be that if this appeal is allowed and the matter remitted to a court below, then these are precisely the sort of questions which will need to be looked at with intense focus by either a specialist independent social worker or by the existing teams, in order that proper information can be placed on the court, so that an assessment of the realistic options can take place. And months will have moved on then. The older child is getting obviously older by the day, and one senses that the prospects of placement of a child moving towards the age of 4, 5, 6, even that's a long way on, it's slowly diminishing. The pool of adopters drops. What's the evidence of that? There isn't before this court, but it's sort of understood within the trade that is the position. And the judges are well aware of that at first instance, because they deal with these cases all the time.
Well, it's not necessary for us to investigate this. I suspect that there will be quite a lot of research that we could find on this particular topic, the age of adoptability, but we don't need to look further into it.
Well, can I just deal with you extremely briefly with ground 2, because there's not much I seek to add to my skeleton in relation to that, but but for all intents and purposes, by the end of hearing 2, the mother was off the table as an option. And one can see that by the force and nature of the conclusion the learned judge arrived at between long passages over about 7 or 8 pages of the judgment between paragraphs 227 and 311, but particularly the last 5 or 6 paragraphs preceding 311 were fairly, it was difficult to see how the learned judge having expressed itself in such clear terms in those paragraphs, there's any coming back from that a few months later. That's essentially the point that we're making. And what did that mean? That meant that when the substantive, well, the formal analysis of the welfare option, the realistic welfare options, came to take place in May, one of the chief ones was already effectively, not formally, but substantively off the table. And so it was more a formal process of box ticking, not too critical, but box ticking in relation to BS rather than a wholesale re-evaluation of the pros and cons of each realistic option. And that's what took place. Hence the nature of ground 2, hence the submission that what took place was in effect linear because she'd been ruled out too early.
Can I just ask you a question on that?
Of course, my lord.
If that is right, because of the structure of the second judgment, what's wrong with that? If the judge has made findings of fact that the mother really isn't fit, now I know that's challenged in the proportionality assessment. Why would it be wrong to take her out of the options if that's what you say was truly happening, notwithstanding paragraph 312?
Well, the learned judge was entitled to make findings of fact on various historical matters because that had already happened. That's fine. She was entitled to make an assessment of risk as to what may happen in the future based upon a risk metric, and but by expressing the views that she did in the earlier hearing, she'd effectively bound her hands in relation to the formal re-evaluation which needed to take place in the light of the additional information from the professional parties on the BS evaluation. That was the time for all of the options to be looked at alongside one or the other. It shouldn't have happened before. So even though formally the position was covered, substantively it was more of the learned judge having in her own mind come to the conclusion, well, I've already sort of dealt with that because I've read my previous judgment, and as I submit, there's no real coming back from that. And what my lord says, well, had she not expressed herself in such terms and saved it all up for later, what would be wrong with that? And I would say there'd be nothing wrong with that because that's what's supposed to happen. But by going a little bit early on that point, she effectively, there was a temporal gap between stage 1 and stage 2. And stage 2 is when the substantive analysis needs to take place. And it couldn't fully take place by then because part of it had already happened. And so in terms of, and this BS emphasised, they should be looked at on an equal footing, formally on an equal footing, alongside each other at the same time. And that did not happen.
Thank you.
In agreement with my lord, I don't see what's wrong with a judge using the second hearing once it had been embarked upon in order to sharpen her understanding of risk and to make further findings of fact. But what is unusual here is that she then declared them. So the question is whether in a difficult case, by telling the parties that she'd effectively foreclosed on one option, then the further that then took all the value out of the further hearing, which was designed to collect together all the welfare factors. I mean, that seems to me to be a narrower submission that we need to consider, rather than saying that the judge should simply not have had any thoughts about this.
Not for the first time. Your Lordship will hear me say, I gratefully adopt and endorse that. I don't know if there's any other matter upon which I may be able to assist at this stage. I'm most grateful.
Thank you very much. Ms. Foxwell.
My lords, you will have the local authorities' skeleton argument set out in the core bundle at, forgive me, page 82. And I'm going to elaborate on some of the points made in that document and do the best I can to answer what has come up in the conversations with the other advocates this morning. May I start by making what may be some obvious general points, but they are, in my submission, important to, if you like, refocus, particularly to understand the local authorities case. The local authorities case, of course, is that this court can and should uphold the decision of her honour Judge Scannell. First of all, as the court is very aware, this was a very difficult case and an unusual case on its facts. And I say that from the perspective of a local authority which has worked creatively and constructively with the family throughout these proceedings and sought to explore all of the options throughout the proceedings and arrived at the hearing in September, putting forward one proposal for outcome and revised that position through the course of the proceedings. I also say it because you can see from the evidence of the social worker, which appears throughout the three judgments, and I'm going to take the court in due course to the final evidence of the social worker in her statement, you'll see throughout those documents the efforts and the attempts that were made by the local authority to work with the mother particularly, to carefully, if you like, get under the bonnet in terms of risk and in terms of denial, and to do everything that was possible to ensure that these children could remain in the mother's care. But in the questions to the other advocates this morning, the court has alighted on a number of the difficulties in the case. This is a case that involved a family where there were significant issues in relation to denial. It is a case in which the assessment of risk was nuanced and challenging, and it is a case which ran over a period of 13 months, and it was a case involving very young children, all of which presented significant challenges for the local authority. I would also say at the outset, and this is the general point, and you'll have picked it up from our document, that the court, of course, is looking at three judgments, and I'm going to signpost the court before getting to the grounds to certain aspects of those judgments. The judgments, of course, have to be read together. And in particular, of course, we acknowledge it is unusual to find the final decision of a judge explained over two separate judgments. But in fairness to the judge, it was her view that the two judgments had to be read together, and it is our submission to this court that the two judgments have to be read together, because it is in reading the two judgments together that you find the holistic analysis which we say the judge undertook, both in terms of her analysis of risk and her ultimate analysis in relation to placement. What I would propose doing, if I may, is before addressing you on grounds, is to signpost, as I said, a number of aspects of the three judgments that I say are helpful to this court and important for this court to have regard to in terms of your decision as to whether the judge has fallen into error. It is acknowledged by the appellants in this case, and it is an important point of your decision and your analysis of the issues, that the threshold judgment in this case is not appealed. And of course, the outcome of the threshold judgment, and that is judgment one, the outcome of that judgment is that the threshold criteria for the making of public law orders, and in particular care order, which is what was envisaged in this case, were met. And in my submission, it is important for this court to look at the basis on which the judge reached that conclusion and the care with which she reached that conclusion. And whatever the outcome of this appeal, whether this court grants the appeal or not, in our submission, the threshold findings stand. And so this is a case in which the court was satisfied that the criteria for making of a significant public law order were met in the case. Now, the findings of the judge were set out in the first judgment, but you'll also find them helpfully summarised, as is the convention, at the bottom of the final order, which is in electronic page 118 of the core bundle. And I think it may be 116 if anyone is using a paper bundle. And you find there an annex to the order of the judge of the 7th of May. And that annex records, as I said, as is the convention, the basis upon which threshold was met. And I want, if I may, just to signpost a few elements of this. And I know the court will be familiar with it, having read the judgment. But first of all, you can see at paragraph 6 that the judge set out or forgive me, at paragraph 5, that this is a case in which the children had suffered significant harm at the time the applications were made, and also a likelihood of further significant harm. Make that point because, of course, in some of the authorities, which the court has looked at and we will go on to look at, in relation to a risk of future harm, there has not been harm suffered on the ground. The nature of the harm, of course, as explained by the judge, and this is page 119, paragraph 6, was physical and emotional harm. And then she goes on to say that the younger child, Z, suffered physical and emotional harm, and the older child, D, had suffered emotional harm and was at risk of suffering physical harm. The court, of course, will know that that was then particularised in relation to the younger child of paragraph 8, and you'll see the judge's reference to inflicted injuries, and that was, of course, her finding in the first judgment. And she set that out in relation to those two, Roman numeral 1 and 2, a hematoma to the left ear and a bruise to the abdomen. And then you'll also see her conclusion at paragraph 10, that the judge was not able to determine which of the two parents caused the injury, and therefore, to use the colloquialism, the parents both remained in the pool, and a positive finding made that the inflicted injury was caused by one of those parents. I pause, of course, to remind the court that at the time that those injuries were inflicted on this child, she was 5 months old. And the judges, and I accept, because the judge accepted that the injuries were at the lower end of the scale in terms of inflicted injuries, but they were nonetheless inflicted injuries inflicted by a parent on a 5-month-old baby. Moving on then, you'll see the failure to protect at paragraph 12 on the basis that if the injury was inflicted by the father, a failure to protect by the mother. The general findings in relation to dishonesty in respect of the injury, you will know, of course.
Before we leave paragraph 12,
forgive me.
It's a feature of this case that this was an additional finding made against the mother, but no finding made against the father, on the basis that the father was a violent man. So, as a result of being the victim of domestic abuse, the mother picks up a failure to protect finding, whereas as a result of being a violent man, the father doesn't. Is that how this works?
My lord, it's a feature of cases in which there are failure to protect findings that, and it is the subject of a judgment, I think, by Lady Justice King in this court relatively recently, in the last 2 or 3 years, that the labelling of a victim of domestic abuse as someone who failed to protect a child is uncomfortable, and if that was the issue on its own, then obviously I see my lord's observation. I'm not going to make any submission as to the rightness or wrongness of that. That is a finding that the judge made. It is an uncomfortable finding, I accept. My lord, then going on to look at the harm and the risk of harm, and this is at paragraph 15, you'll see there the particularisation of the risk of harm that arose from the domestic abuse between the parents. And there are a number of elements of this which were relevant to the judge's assessment of risk, and we would say on behalf of the local authority are relevant to your analysis of her assessment of risk, but particularly if one looks a finding that the older child had suffered emotional harm from being exposed, and you can see there, to the volatile, violent and abusive environment, and in particular that child being caught up in a violent incident between the parents, that being the incident in January 2023, which was the catalyst for the first involvement of the local authority. You will see particularised there at Roman numeral 3, or forgive me, Roman numeral 2 before we go to Roman numeral 3, you will see particularised there a number of occasions on which the second respondent assaulted, that is, the father assaulted the mother. And within the judgment, the judge concluded that that had happened on 5 occasions. Within those 5 occasions, there were 2 which, on the local authority's submission, were serious and significant. One was the incident of non-fatal strangulation, in which the mother described the father putting his hands around her neck and threatening to kill her. That was a finding that the judge had made. That happened in Pakistan. I don't need, I hope, to make any further submissions as to the seriousness of that in terms of it being at the upper end of the scale in relation to domestic abuse. And secondly, the incident on the 30th of January 2023, when the father assaulted the mother in the presence of the older child. And the judgment, the first judgment, the judge found that the account the mother had given to the police of that assault was accurate, and that it involved the following: dragging the mother by her hair, kicking her, hitting her, striking her to the face and causing injuries to her face and her head, that the incident went on for 10 minutes and it was in the presence of the older child, and at some point in that incident the older child was in the mother's arms. And of course that had two consequences. First of all, a real risk of that child herself being caught in the crossfire or being physically injured, and of course the emotional harm caused to that child of being present when those things happened to the mother. Now, my lords, I make those points just to remind the court that those were the key elements of the judge's findings in the threshold judgment.
Could you just clarify one thing?
Of course.
You mentioned 5 occasions.
Yes.
And you linked that with paragraph 2, which was Pakistan.
Yes.
Is it right to say that the judge found 5 occasions in Pakistan and then the rest? Or is it that we, which I think had lodged in my mind, that the judge was saying that it wasn't just one occasion, as the parents were compelled to concede. It was 5 occasions in all, was her.
The judge was saying 5 occasions between Pakistan and the UK.
Yes,
And
exactly.
that was
So it's
based on
not
the
just 5
mother's-
occasions in Pakistan and the others.
No,
No.
forgive me.
So the judge's estimate of the number of occasions on which the father had assaulted the mother, although she may have been suspicious there were more, was 5, and they included, as you say, 2 serious episodes of particular seriousness.
Yes, and my lord, she took that from the mother's own reporting to the
Yes,
police.
I wasn't meaning to go into why that was, but I just for a moment thought you were saying that it's 5 times in Pakistan and then sometimes in this country.
5 occasions, which included the non-fatal strangulation and the incident of the 23rd of January, some of which happened in Pakistan and one at least of which happened in this jurisdiction. My lords, then to return, forgive me, just back to the order. My lords, just to return to the order, the point I was making before my lord's question, which is, of course, just to remind this court that those findings are the factual foundation on which the judge then went on to proceed the question of risk in relation to the second judgment. And my lord, we do, and I'll get onto this in a moment when I come to deal with ground 1, but we do on behalf of the local authority take issue with the characterisation of this case by the appellant as being only about an incident of inflicted injury in relation to the younger child, and that being at the lower end of the scale. One has to look at the wider context because of course, the circumstances in which the inflicted injury occurred was against a backdrop of domestic abuse between the parents. And in our submission on behalf of the local authority, it's uncomfortable and unattractive to seek to downgrade the seriousness of the findings that the judge made in relation to domestic abuse. Those findings in my submission are serious and they are significant, and that is how the judge describes them in the threshold judgment. Now, my lords, the court will know this, but let me just remind the court that going into the proceedings which led to the first judgment, and this I think arises from my Lord Justice Jackson's question to Mr. Rees at the outset of this hearing. Going into the judgment in the proceedings, the hearing in October of 2025, it had been the expectation and the intention, firstly of the court and secondly of the parties, that that would be a final hearing. At the beginning of the hearing, it became apparent that the local authority wanted to pause and reconsider its care plan. And also the court indicated that it was unlikely to be in a position to reach final decisions, and therefore the hearing was a threshold hearing. And after that hearing, as you know, the judge indicated that the local authority should begin what was called the stage 1 assessment, as outlined by the independent social worker, Miss Gemma Williams, whose evidence was heard and accepted by the court.
Just help a little more about that. Right, so the hearing took place from the 6th and the 10th of October,
Yes.
and then the 4th and 6th of November. It had started out being an intended final hearing for everything.
Yes.
Right, so I'm sure this is explained in the papers, but could you just unpick why it didn't turn into a final hearing for everything?
Well, my lord, it is something that the judge deals with in the judgment.
Yes.
So if I can just take you to those paragraphs of the judgment. Going into the hearing itself, the local authority's care plan had been one of rehabilitation. And of course, there was a difference of view between in terms of the recommendation of the independent social worker, Ms. Williams, and the local authority. So if my lord just allows me to pause for a moment while I find that part of the threshold judgment where the judge deals with this issue, because she does set it out as to why it started as one thing and ended up as the other. If you'll just bear with me.
Paragraph 2, page 123.
I think she could, forgive me, but I think she deals with it in more detail. But paragraph 2, page 123. Yes, and I think, my lord, she also deals with it elsewhere, if you'll allow me perhaps to come back to this question. But the reality then was, of course, that there had been a pause. This is just the mechanics of the hearing. There had been a pause in the process because the parents indicated they wished to consider making concessions on threshold. The judge allowed that exercise to take place. The concessions were not sufficient, and therefore the hearing continued as a threshold hearing only. And you can see the judge signpost that at paragraph.
I know that this is all a bit technical, but I'm just anxious to understand this. I mean, it was an unusual case mainly because of the immigration aspect. The other aspects of the case weren't particularly unusual for the family court. And given the ages of the children, an all-in-one hearing had many, many advantages. So I'm not yet, and of course there was some professional disagreement. It's not in itself uncommon either. That's what, of course, that resolved. But I'm not yet understanding why it ended up with the thing being cut up, with it only being threshold. If the answer is not enough days, then fine. But at the moment, I don't understand how what is in some senses quite a normal case ended up being dealt with in chapters.
Yes. My understanding, and I'll be corrected, I'm sure if I'm wrong, my understanding was that going into the hearing in October of 2025, the local authority's care plan was for rehabilitation of the child to the mother's care. At the beginning of the hearing, the local authority indicated that it wished to reconsider that care plan. And that is why it wasn't a final hearing.
Why?
Well, my lord, there were a number of reasons for that. First of all, there was the evidence of the social worker, Miss Williams. Secondly, my lord, there had been, as I understand it, some discussion with the judge at the outset of the hearing, and I'll make sure that I'm right about that, because obviously I wasn't at the hearing. Mr. Douglas was present at the hearing, and as were other juniors sitting behind. But the local authority indicated that it wished to pause and reconsider its final care plan.
Okay, but this is against a background where split hearings are maybe necessary where there are very serious factual allegations have been made. And it's impossible, particularly in single issue cases, it's impossible to make a welfare decision until you know the answer to the serious allegation. But this wasn't that sort of case. So it wasn't listed for a threshold hearing because everybody had to know the answer
Well-
to a single question before it went on to decide welfare. Because
Well-
otherwise we're back in an era where all hearings are always split, which is not where we want to be.
No, of course, and that wasn't the intention, the expectation of anyone in the case. But my lord, it seems that the answer may lie in the judge's own judgment. That in the threshold hearing, the judge heard evidence from Miss Williams, and Miss Williams set out her analysis of risk at the time, and that, of course, was at variance with the local authority's analysis of risk going into that hearing. And you will know from the judgment that the local authority's analysis of risk was one which the local authority, as it were, adhered to in the course of the threshold judgment. Miss Williams gave evidence to the court, firstly in writing, and secondly oral evidence, having carried out her assessment of the parent's parenting capacity, that she had reservations about the ability of the parents to work honestly and openly with professionals. You will know that Miss Williams set out a 3-stage process to be considered depending on the findings in the case. And of course, that mainly hinged on the inflicted injury, whether or not a finding was made as to either of the parents having caused the injury, and depending on a finding as to which of the parents had caused the injury. So to answer my lord's question, the reason which the judge gave for pausing, the reason why the local authority didn't stand over its care plan, as it were, going into and coming out of that hearing, was because there was a need, depending on the judge's findings, for an opportunity to analyse the risk and assess the risk in the case. That is what happened between the first judgment in November 2024 and the second judgment and third judgment in April and May, 2025 and 2026. So I accept my lord's point that the convention and the expectation is that all of that should be dealt with in a single hearing. But in this particular case, it was the view of the professionals in the case, and it was the view of the judge, that there needed to be a pause between the first and the second for that analysis of risk to take place. And my lord, it must follow from that, and in my submission this is evident from the threshold judgment, it must follow from that the framework, if you like, for the assessment of risk, and I'll come to that in a moment looking at the second judgment, but it must follow from that the framework for the assessment of risk was shaped by the judge's findings as to the nature of the harm that the children had suffered, but also the issues that she raised about the dishonesty and the lies which were told by the parents. And there are a number of aspects of that which in my submission explain why there was a need for pause. There was the fact that the judge concluded that she was unable to identify the perpetrator of the inflicted injury because of the way in which the parents had lied about what had happened and when it had happened. There was also the fact that the parents had continued to lie about the nature of their relationship, and that raising, if you like, a red flag in terms of risk of future harm. And there was the fact, as I said, that Miss Williams had indicated there needed to be a stage 1 and a stage 2 process in terms of the, if you like, rehabilitation plan which the local authority had envisaged. And in particular, we'll come to this in a moment when we look at the second judgment, in particular Miss Williams said that after, or recommended, the judge accepted this, after findings were made in terms of inflicted injuries, after findings were made in relation to domestic abuse, that there had to be an opportunity for the local authority to do some work with the parents in order to understand the parents' acceptance of those findings. And if it was a situation, as is common, where the parents did not accept the findings, whether or not it was possible for the local authority to proceed to stage 2, depending on the nature and extent of the parents' denial. So, my lord, that was the position between the first and the second hearing. I hope that answers my Lord Jackson's questions and observations. My lord, when I made the submission at the outset that this was an unusual case. The way in which the court progressed and the fact that the court gave an opportunity for an assessment of risk between one hearing and the other, in my submission, is to the court's credit, and it is to the local authorities' credit that an opportunity was taken to follow the framework that was set out by Ms. Williams and to try to undertake work in order to, if you like, adhere to a rehabilitation plan, which had been the local authority's primary objective. So, my lords, obviously for this court, when we come to look then at the second and the third judgment, as I said at the outset, as is obvious and as the court will be very familiar, the foundation for the analysis of risk, which the court engages in the second and third judgment, is the findings that the court made in the first judgment. May I then turn briefly to the second judgment and make a number of submissions in relation to that? When the court looks at the second judgment, and you find the second judgment or a transcript of the second judgment, which was given by the judge on an extempore basis, at page 157.
Which is, in fact, it's a note, isn't it? I think it's an approved note rather than a transcript.
It is, that is the case in relation to this judgment. The other two are transcripts, but all three judgments were given extempore by the judge. So when one turns to look at page 157, if I could just pick up on the point I was making a moment ago in terms of the jumping off stage, if you like, for the court. The judge sets out in the first 3 pages of that judgment the findings that she had made and revisits those findings, if you like, reminding herself and any reader of the judgment as to what the basis of her findings in relation to threshold. And then at page 163, she sets out the reason for the break between one judgment and the other. And this is at paragraph 50. And she says, my fact-finding judgment ended by giving the local authority an indication of matters that would need to be considered if, having undertaken the stage 1 assessment, it wished to place a plan for rehabilitation before the court, and she goes on to set out the court's position in relation to that. At paragraph 164, she references the fact that there had been a hearing in December, and you'll see this at paragraph 57, at which the parents had made, or the mother had made an application, paragraph 59, for a further assessment by an independent social worker, and that being refused. And then she goes on at page 169 to set out the position of the parties. Page 165. And so going into the hearing, the court will see that the local authority's position had changed. The local authority at paragraph 66 was inviting the court to make care and placement orders. She sets out the mother's position, which was for the children to be returned to her care. And then at paragraph 71, she notes that just before the court heard submissions, so after the court had heard evidence, before the court heard submissions, the mother had changed her position in relation to separation from the father and set out that she was proposing separation from the father. Now, my lord, may I make 2 general points about this judgment, which I hope answer some of the questions that were raised by my lord, Lord Justice Jackson, to Mr. Bagchi. A question which was raised was, why did the judge not pause the process at the beginning, rather than undertake a risk analysis, get to the position of realising that she did not have before her sufficient evidence in terms of a BS analysis? So why did she undertake the process at all? And in my submission, the answer to that comes from the judgment itself, because what the judge did in the second judgment was undertake a risk analysis according to the guidance which is provided by the higher courts. And you can see that set out by the judge's recording of the law and the legal framework within which she is operating. And in my submission, there is no error in that. At paragraph 74, She refers to my Lord Justice Jackson's judgment in the LG case, brought to her attention by Mr. Rees, and a paragraph 18, page 166, she sets out my Lord's guidance and the framework set out in the Re-F case. And those were the questions that the judge asked herself. And in my submission, she answered those questions in the body of that judgment. And in my submission, she can't be faulted for the way that she did that, nor could this court say that she was wrong in the way that she undertook that exercise. The questions that were asked or are set out to assist judges in the analytical exercise which they are required to undertake, those questions are answered by the judge in the second judgment. Where the judge arrived at the end of the second judgment was that she concluded that neither the local authority final evidence nor the guardian's final evidence sufficiently grappled with the BS analysis or the balancing exercise as to, having undertaken the risk assessment, what is the impact of that risk assessment on the welfare of the children, or how one analyses that through the prism of welfare, and then moving on to the question of what is the correct outcome for these children, bearing in mind questions of necessity and proportionality within the Human Rights Act framework. Just pausing for a moment to answer a question which was asked by my Lord Jackson, and to assist the court, I hope, in terms of understanding why the judge reached that position. The local authority evidence going into the final hearing in April, we would have to acknowledge on the behalf of the local authority, didn't properly grapple with the BS question, nor did it set out a proper and full analysis. In my submission, the Guardian did so more thoroughly, but the judge concluded that it didn't provide her with the evidence she required to carry out that exercise for herself. And I pause there, if I may, to make two submissions. First of all, a judge cannot be criticised if the judge reaches the conclusion that neither the local authority nor the Guardian has provided the court with the evidence that the court requires in order to undertake the balancing exercise for itself. In the line of cases which led to BS, and indeed the BS decision itself, this court repeatedly reminded judges and practitioners that there was an obligation, first of all, on the local authority and the Guardian to provide that evidence to the court, and then for the court itself, in reliance on that evidence, to undertake its own balancing exercise. And in my submission, it's harsh to criticise this judge for doing what she ought to have done. If she didn't have the evidence, if she didn't have the analysis, if she didn't have the information from the local authority, and she concluded that she didn't, then in my submission, she was right to pause and to ask for that evidence to be brought forward. Had the judge gone on in the second judgment to reach a final decision, then in my submission, she would have fallen into error. And it's also a second point that we would make, is it was very much central to the mother's case, rightly, that if a judge was going to sanction the making of placement and care orders, that she had to have evidence that allowed her to do that. It is part of the guidance which is given in the line of cases which my Lord Justice Jackson has given judgments in, beginning with Re-F, referred to by the judge, carrying through to the LG judgment and the Re-N judgment. the thread that runs through those judgments is to remind judges to undertake a risk analysis, and then following on from the risk analysis, to undertake the welfare evaluation and the balancing exercise. This judge did the first part, she rightly paused, asked for further evidence, and then she does the full exercise. Going in then to the second hearing, or forgive me, the third hearing in May, and I, for fear of repeating myself, I do remind the court that the judge at first instance makes the point in this third judgment that it must be read together with the second. Neither of those two judgments can stand alone, because the complete analysis undertaken by the judge runs through both of the judgments. If one reads either of the judgments on their own, they don't, in my submission, stand on their own two legs. Going into the hearing in May, it's helpful in my submission to look at what the judge had by way of evidence that she did not have in the April hearing. So first of all, having requested the analysis be undertaken, she had the local authority statement, the final statement, completed by the social worker. And my lords, you will find that at page 393 of the core bundle. And that statement is dated the 21st of April 2026. And I'd like, if I may, just to signpost you to a number of elements of that statement, because that statement is crucial to the decision which the judge reaches in the third judgment. She sets out, first of all, we're at page 394, the evidence from the mother in terms of her position and the case that the mother put before the court. And then you'll see an explanation at paragraph 8 at the top of page 395 why the local authority was undertaking a further assessment, or actually that's wrong, why the local authority was undertaking an assessment that it hadn't previously undertaken. And she sets out a number of issues in relation to the mother. And at paragraph 11, she sets out the position in relation to the children possibly remaining in the mother's care. Signposting, you will see second sentence, the local authority is unable to recommend that the children remain in the care of their mother. She identifies emotional harm to the children by way of removal, and she identifies the risks of the children remaining in her care. And then she goes on at paragraph 12 to consider the children remaining in the care of both parents. And down through paragraphs 13, 14, and 15, she deals with the benefits and detriments in relation to that. And at paragraph 16, she sets out, if you like, the consequences for the children of removal in terms of the impact on their attachment. And then at pages 18, or forgive me, paragraphs 18, she sets out what the local authority's position is in terms of risk. So no protective factors to mitigate the risk. There is a very brief consideration at paragraphs 19 and 20 of the children remaining in foster care, which is my Lord Dingemans' question earlier as to the benefits and detriments of that. Very much aligns with my Lord Justice Jackson's observations as to the ages of the children and that not being an attractive or appropriate scenario in this case. And then goes on at paragraph 21, 22 and 23 to set out the benefits and detriments in relation to adoption. Now, paragraph 21, you can see there is a succinct and precise analysis of the benefits and detriments in relation to adoption. And folded into that in my submission, or threaded through that in my submission, are elements of the welfare checklist under section 1.2 and 1.4 of the Adoption of Children Act. And I pause there, if I may, to pick up on my Lord Justice Jackson's point earlier that, of course, this is a document prepared by a social worker. It's not a lawyer's document. And when the court comes to look at the depth with which this particular document explores the welfare checklist options, one has to bear that in mind. And then she goes on at the remainder of that evidence to set out the local authority's view in relation to realistic options and the local authority's conclusion. May I also, and I won't tread on Mr. Barnes' ground, because Mr. Barnes no doubt will want to take you through this in more detail, but may I also signpost you to the Guardian's analysis, which was available to the court for that hearing. And in my submission, the Guardian's analysis provides further analysis and further balancing than was undertaken by the local authority. And in my submission, it is a very comprehensive document. And you'll find the analysis follows on from the local authority document, but if I may particularly take you to the permanence analysis at page 411. Now, the global submission that I would make to this court is this analysis by the Guardian is a paradigm example of what social work professionals should do in order to set out their own decision making, but in terms of reaching a conclusion and undertaking their own balancing exercise. And I would invite the court to read that document right through the analysis that she undertakes as to paragraph 5.4, the children's relationship with their mother, at 5.5, the benefits if the children remain within their family, as to maintaining relationships with the wider family, the cultural ties, that being, of course, one of the considerations under section 1.4. Paragraph 5.6, the cultural benefits to the children of maintaining their cultural identity. And then going on down through paragraph 5.7 to set out those benefits, and recognising at paragraph 5.6 that if the children were able to express their wishes and feelings, that they would be to remain within the family placement. That analysis from the Guardian continues down over several pages, and the Guardian then at paragraph 514 and 515 provides her views as to risk, as to the difficulties with the placement with the mother continuing. And at 518, she sets out her view that the children could not be protected under a care order, and the risks of reunification of the parents, the risks of physical injury, the risks of domestic abuse. It's also right that the Guardian does signpost, although not in any great detail, and this isn't any part of our case, but it arises from the questions the court asked earlier, the Guardian does signpost at paragraph 5.22 that there is a question mark here about where the mother is going to be able to live and what her circumstances will be as a consequence of her asylum status. And the other aspect of the Guardian's analysis, which is helpful to this court, is at paragraph 5.31, where she deals with long-term foster care, and then 5.36, where she deals with adoption. And in my submission, that carries on from 5.36 right through to 5.45, where the Guardian weighs the options. Now, in my submission, it would be difficult to criticise any aspect of that assessment. And when one puts that together with the local authority's assessment, that is the evidence which the judge had before her at the beginning of the third hearing, which he didn't have before her at the beginning of the second hearing. I've taken the court through that evidence in some detail because in the third judgment itself, there's relatively little reference to that analysis from the judge. However, this court, in my submission, has to recognise what the judge says at the beginning of that judgment and has to work on the basis that the judge accepts that evidence and that she had that evidence in mind and that that evidence informed her own analysis and her own balancing exercise. And we can see that if we turn then to the third judgment, and forgive me for going through these in some detail, I hope it will truncate the exercise in relation to grounds. But if we look at the beginning of the third judgment, the transcript of the judgment, you will see that at paragraph 3. First of all, she sets out some references to the previous findings and the previous judgments, explains why there is a third judgment, and then, forgive me, just looking for a reference. Oh no, just bear with me a moment. I've just lost a reference which I wanted to take the group to. Yes, if one looks at paragraph 26, so page 204, this follows on from her short summary of the earlier hearings, and in particular the second judgment. She says, I then turn to the evidence I have heard. At the hearing itself, she sets out it was limited but targeted and appropriate evidence from the social worker, mother, father, and guardian. And then she says, I've had the opportunity of rereading my previous judgments. I've had a condensed bundle, which I have read, and I've also been sent some updated case recordings. And then she goes on in the remainder of that part of the judgment, dealing with the evidence, to deal with the oral evidence that she heard. But, my lords, you must proceed on the basis that also underpinning her analysis is the evidence that she has read, because that is what she tells you at paragraph 26. And the reason why I make that point is obvious. The analysis which underpins her decision is there in the local authority evidence, but particularly also in the guardian's evidence. And when this court comes to look, as you must, at whether this judge undertook her own balancing exercise in the correct way, whether she followed the guidance set down by my Lord Justice Jackson in the BF case and other cases, whether she followed the guidance set down in the BS case in terms of arriving at a conclusion which is informed by weighing all of the realistic options through the prism of welfare and proportionality. That is the starting point. That is the evidence on which she is relying to reach her decision. When one looks then at the evidence that the judge summarises from the social worker, it's very much on the question of whether her analysis of risk in the second judgment has changed. And the reason, of course, why she had to consider that question, has my analysis of risk changed, is because going into the third hearing, although there was only about 6 weeks between the third hearing and the second hearing, the mother's case was, I have now separated, my circumstances are different, and therefore you have to look again at the question of risk. And that is what she did. She heard evidence from the social worker in relation to the question of risk, and that begins at paragraph 29, page 204, as to whether or not there was reason for the court to change its analysis of risk on the basis that the mother had separated. Was that a real separation? Was it a stance taken for the litigation? And the judge analyses that in those paragraphs, all the way down to paragraph 37, where she sets out a debate, as it were, between the local authority, the guardian, and the mother, or those representing the mother, forgive me, as to whether that was a genuine issue or a genuine separation, or whether it was a litigation stance. So, my lords, she relies on the assessment of risk which she undertook in the second judgment, but she also revisits it, or asks herself whether she needs to revisit it. And in my submission, that is an appropriate course for the judge to take. She would be criticised if she didn't. It's the judge considering whether there is a change of circumstances of a nature and a quality which alters her original analysis of risk. When one then goes on to look at the analysis that the judge undertakes, You'll see that begins at paragraph 42, and that's at page 206 of the electronic bundle. And she sets out very clearly what the risk is in this case as a consequence of the exercise that she had undertaken in the second judgment. You'll see at the second sentence in paragraph 43, it has always been about the risks that flows from the judgment, that being the threshold judgment, and the parent's ability to acknowledge that risk and thereafter to work with the local authority safely to effect change and to mitigate that risk. That is the case whether they are separated, whether they are separate or together. My lords, there can't be any criticism of that analysis. In my submission, that is where the judge was driven to by the evidence, and it is a conclusion that the judge was entitled to reach in relation to the evidence.
I think, just to put this to you,
Yes.
any statement that the welfare determination has always depended on risk, is that a sound approach?
The judge may be conflating two issues. As this court has set out repeatedly, the welfare evaluation follows the evaluation of risk, and I see my lord's point.
There might be very obvious cases where there's been catastrophic abuse, and where the two things conflate.
Yes.
This wasn't one of those cases.
Well,
I think I'm just pausing you there because
yes,
if you're going to move ahead
yes.
on the assumption that everybody knows that welfare means risk.
Well, risk is an element of welfare, as my lord is aware, from the welfare checklist under section 1.3, from the welfare checklist under the Adoption of Children Act. One of the factors, and this of course arises in the LG case, it arises in the Re-T case, it arises in the Re-F case.
Yes.
One of the factors that a court has to consider is the risk of future harm, whether the children suffered harm.
Where does the judge consider, and now I've interrupted you, where does the judge consider the consequences for the children if they were back with their mother and things went back to the bad old days? Where does she consider what the consequences are of the harm eventuating for the
My
children?
lord, that is something which threads through the two judgments, and I'd need to take my lord back into the second judgment to deal with that, because the judge does signpost in my submission the possibility of risk of future harm and the consequences for the children if that harm were to materialise. So just forgive me while I take the court back to the second judgment. Yes, my lord, she sets out the nature of the risk and the consequences in the second judgment at page 168. Paragraph 79.
Yes. Well,
So-
I mean, she directs herself as to what the questions might be. Might be used. It's not the law. It's just intended to be guidance. But we got we know what we're talking about. We're talking about the risks arising from physical mistreatment. We're talking about the risks arising from a domestically abusive relationship between parents who can't be trusted to be frank with outsiders. So that's the nature of the risk. But what the judge needed, as it seems to me, to also do before moving on at page 170 to managing the risk, is to consider what the consequences are for the children of these risks. I mean, just to put to you a concern that I have, there appears to be an unspoken assumption that the risks that were raised by this case make a placement with these parents out of the question. The nearest I can come to is paragraph 124 on page 174, which is a reference to the social worker's evidence, described as unsurprising. Yes, of course, but isn't there a possibility that that's treated as if it's the answer to the case?
Well, my lord, it's a
Why, does the second judgment deal, no doubt, with the question of whether that effectively foreclosed on the mother's case, but for a sort of right of appeal based upon the things she'd done in the next 6 weeks? But leave that issue for you to deal with separately. But that doesn't answer that statement. I mean, worst case scenario, death. That statement doesn't distinguish between cases that require child protection and cases that require adoption, does it?
well, my lord, that is not the place in my submission for the judge to deal with that.
So where if we don't find it there,
Yes.
where do we find it? It's one of the main questions of what are the consequences for the children
Yes.
of the harm that has been identified? Because, as you well know, your local authority can't take away all children who suffer harm, even significant harm. It's not right, and it's not possible, even if it was right. So where does the judge explain why the children's lives with their two parents would self-evidently be so bad that they can't live in that environment? Or with the father being an ever-present risk? That's what I'm...
I understand my lord's question. May I deal with the question before the question? So my lord's observations a moment ago, where does the judge deal with consequences? And may I just address what the judge sets out at paragraph 124? I acknowledge that is a succinct account or a succinct analysis in relation to consequences, but it is an analysis in relation to consequences, and one has to accept that the judge is importing into that paragraph or reducing in that paragraph the evidence that she has heard from the social worker about the nature or the consequences of the risk. Nature, in my submission, the judge deals with in some detail. Consequences she deals with in less detail.
But it wasn't sorry to interrupt you, it wasn't consequences the whole point of this case. That's really the fulcrum of the whole case.
Well, my lord, the
In
consequences...
124, if you don't show us some other passages in the judge's reasoning, is doing an awful lot of work.
Yes, but let me take the court through, if I may, a number of other passages, but just dealing with page 124, what the judge sets out there, in summary, the judge is accurate as to consequences, and no one can dispute that in terms of...
I'm sorry to interrupt,
Not
but
at all.
what was the evidence that these children were at risk of death? Obviously everyone is, but what was the evidence that these children were at an elevated risk of death at the hands of their parents?
My lord, there's no evidence to suggest these children were at risk of death. There is evidence that the mother found herself in circumstances with non-fatal strangulation and a serious assault that she may have been at risk of serious injury or death. I accept that there was no evidence that the children were at risk of serious injury or death on the evidence which was before the judge. So that is an overstatement on the part of the judge, and that is a general observation from the judge as to the consequences of domestic abuse. I'm going to just turn my back for one moment just to get some assistance from Mr. Edis. And it may be, my lord, that I need to pause to answer that question properly.
Sure.
Whether I pause now to answer that question, understanding that that is the key question for the court and wanted to assist the court in answering that question, it may be that Mr. Douglas and I need a moment to provide further examples to the court.
Well, I'm sure you'll have that opportunity.
I'm very grateful. Do you want me to pause now, given that it's 10 to 1, for an adjournment, so I can deal with that question and deal with it, I hope, quickly when I return?
There's a bit in paragraph 79, lines 2 and 3, if that helps.
There are a few other places, but rather than my cherry picking, as it were, I'd like to try to answer that question, understanding that is the key issue for the court.
Shall we pause now and come back?
Well, I think, I mean, if we continue, we should pick it up.
Exactly. Yep. I think we'd prefer that you carry on. We won't finish before lunch. I don't know that you will finish before lunch, actually. And you will certainly, therefore, have the opportunity during the short adjournment to pick up anything that you need to tell us about.
Yes, very well. Just forgive me, I'm trying to find my place before these questions were asked.
I'm sorry, I interrupted you, and I'm sorry for that, at the point when you were looking at paragraph 124. But I think you've been taken to that in response to other questions.
Well, I think where I was, and if I'm wrong about this, I'm sure you'll correct me, but I think where I was in the third judgment, seeking to assist the court to understand the evidence that the judge had read and heard, that evidence forming the foundation of the judge's balancing exercise in relation to BS, and in particular, how it was that the judge paused between one hearing and the other, between one judgment and the other, to ask for and to obtain evidence which would assist her in terms of the balancing exercise. May I just pick up on, then I'll go on to deal with the grounds, may I just pick up on one point made by my lord, and it relates to the question of the consequences of the risks materialising. And it is the suggestion that the judge, or the submission that the judge paused at the end of judgment 2 to undertake, to put it crudely, a window dressing exercise. And that the only reason she did that was to avoid a situation perhaps in which we now find ourselves, to avoid an appeal, and that it is clear at the end of the second judgment that the judge has reached a final decision. In my submission, that is unfair to the judge herself, because if one reads the two judgments together, she doesn't, at the end of the first judgment, land on one option and one option only. She recognises that it is a deficit in the evidence before her, that was what the local authority appeared to have done. And therefore she, as it were, pushed back on, or requested the local authority to provide her with all of the options and a proper consideration of all of the options. And it is, in my submission, important that this court does read the two judgments together. That is what the judge says should happen. The judgment, as I said, stands alone. May I turn then to deal with the grounds? And I would signpost you, if I may, to the skeleton argument from Mr. Douglas and I, and in particular where we begin to deal with the grounds that paragraph 31. And you'll find that at page 95 of your bundle. Now, we deal with the grounds in the way that they are addressed by Mr. Rees, by the appellant. and in particular looking at ground 1A, the submission that the judge's conclusions were neither necessary nor proportionate in all the circumstances when considering, firstly, the last domestic abuse episode having occurred more than 3 years ago. And there are just a few points I would make in relation to that, and you can see we've set them out in our document. That in our submission is a fundamentally problematic assertion by the appellant, because the nature and the seriousness of the domestic abuse is downgraded if one simply says that there has been no recurrence of it in 3 years. The judge was clear that she could not be confident that that was the case, first of all. But secondly, over the past year before the hearing, the mother, of course, was living in a mother and baby placement, and the contact between the parents and the children, or forgive me, the father and the children, was supervised. I don't want to repeat points that I've already made, but the difficulty with the submission that looks at the date at which the last incident would have been found by the judge is that it ignores the seriousness of the judge's findings as to the nature and the character of the domestic abuse in this case, and I've already made those points. And so the analysis of proportionality in relation to domestic abuse is not just about the it being recent or not recent in terms of its occurrence. It is the seriousness of it when it did happen between this couple and the risk of a recurrence at some point in the future. And that goes to the judge's assessment of the nature of risk, which we submit this court should accept. Dealing with ground B, the inflicted injuries, in my submission, these two sub-grounds, if you like, go together. We acknowledge, of course, because the judge acknowledged that the inflicted injuries in this case were at the lower end of the scale. That wasn't apparent at the time the proceedings were taken, but that was apparent from the evidence before the judge and the findings that she made. But I do remind the court of the submissions that I made earlier, the age of the child, the context, if you like, and the backdrop against which the inflicted injuries occurred. In other words, against a backdrop of serious domestic abuse within the parents' relationship. And the inability of the judge to reach a finding as to the perpetrator because of the parents' dishonesty. Each of those three factors feed into the relevance of that finding. So it isn't just as simple as saying it was at the lower end of the scale. I don't know that I can make much more by way of submissions as to what is in our skeleton in relation to the mother having complied with professional obligations over the previous 12 months. And I don't make much more of that because that was acknowledged by the local authority, it was acknowledged by the guardian. It is a fact that the mother did work effectively to a point in terms of her basic parenting in the placement. But of course she was supervised 24 hours a day. She continues to be supervised 24 hours a day. And the effectiveness or the adherence to professional obligations and guidance is watered down to some extent by the mother's dishonesty and her denials as to the nature of the parents' relationship. And by dishonesty, I mean the judge's findings that the mother was dishonest about the domestic abuse and that she continued her denial throughout each of the three hearings. And so that does raise some red flags in terms of observations. And it's important that I make clear because the social worker was clear in her evidence, her oral evidence and her written evidence to the court, that she did acknowledge the progress that the mother had made, and she did acknowledge the positives of the mother's care of the children and the attachments.
You said a moment ago that the extent of the injuries wasn't clear when the proceedings were taken,
Yes.
you'll be able to check this, but we're aware that there was concern about other findings at the hospital when the mother brought the child there. But could you just tell us whether those concerns had been dispelled before or after the proceedings were brought? I appreciate that there were concerns at the earliest stage of the child protection investigation, but I'm not aware when it was that the concerns were dispelled.
My recollection is once the medical evidence had been received, therefore before the hearing in November, the
Right. So the risks relating to the head and the leg, was it?
head and leg.
Those were still live issues when the proceedings started, were they?
They were live issues when the proceedings started.
I see. I hadn't appreciated that.
In the threshold judgment, the judge sets out the medical evidence, but the suggestion that there may have been a head injury or
Right. Well, would you take instruction perhaps about when it became clear that the local authority was not proceeding in relation to those matters, so that
Yes.
we can, as it were, know where to draw the line? No need to do it now. Would you also be able to tell us, please, whether either in relation to the domestic abuse, when the mother reported it in January 2023, or in relation to the issue of injury to the younger child, which became apparent at whatever level, in fact at a higher level than the court then had to consider in March 2025, whether the local authority made any application to the court at any stage for the removal of the children from their mother?
yes,
You'll be able to help us with that when we come back as a matter of point of fact.
yes. I don't intend making any further submissions on ground one. Is this a good place to pause?
It is. Thank you very much indeed. We'll resume at 2 o'clock. Thank you.
All eyes in favour?
Anyway,
The court will be locked with.
It will be.